Hello all, welcome back to the Indian Patent Agent Examination video series by Pathways Consulting Solutions. Today we will look at the Indian Patent Act 1970, Chapter 5. Opposition Proceedings to Grant of Patent. The Indian Patent Act 1970 via Chapter 5 provides a provision for the public to oppose any patent that the public feels has not complied with the sections or requirements of this Act. Now, the Indian Patent Act has prescribed there are a lot of rules and there are a lot of timelines as well as certain requirements for any new invention, any inventive or non-obvious invention to become a patentable subject matter and having a commercial applicability to be granted of a patent. So we looked in the previous sessions about the different provisions for applications of patent, what is publication of patent and what is examination of patent, where the patent officer or the examiner looks at all the requirements for patent and if that application has satisfied so. And then the examiner may put the application for grant. Now, after publication, the public is provided with few opportunities if they feel that the grant of patent could be prejudiced and it has not fulfilled all the conditions or specified conditions according to this Act, then one of the most important provisions is called the opposition filing. Under Section 25, there are two types of opposition a person can file. That is 25(1), which is a pre-grant opposition, and 25(2), which is a post-grant opposition. The most important difference between a pre-grant opposition and a post-grant opposition are two in numbers. Point number 1, the pre-grant opposition has to be done any time before the controller decides on the grant of patent, or any time before the controller passes the order of grant of patent. Any interested person can file for a pre-grant opposition. So the second point is any person, which means I need not be just in the field for them. So I can be a public who has not even known about the technology. I'm just reading about the technology. I have a publication which is very relevant to it. Then I am given the opportunity to file for a pre-grant opposition. Whereas a post-grant opposition has to be filed within 1 year from the date of grant of patent, and it has to be filed by an interested person. So I have to be a person from the same invention related to the same industry, and only then I can apply for a post-grant opposition. So major difference between Section 25(1), which is a pre-grant opposition, is before the grant of patent. 25(2), post-grant opposition, is within 1 year after the grant of patent. And the second important difference is 25(1) prescribes any person can file for a pre-grant opposition, whereas 25(2) prescribes that only an interested person has to file for a post-grant opposition. Looking at 25(1) in this slide, where an application for a patent has been published but a patent has not been granted, any person in writing according to the prescribed formats giving all the statements and facts file for a pre-grant opposition. There are certain grounds upon which a pre-grant opposition has to be filed. So it's not that I don't like the inventor and I can file. So what grounds, what facts am I going to give to examiner to say that this particular patent should not be granted? Point number 1, that the applicant for which the patent has filed has wrongfully obtained the invention. So it is not his invention, he has obtained it from somebody else. That's called as wrongful obtainment of the invention. So if I have facts relating to it, I can file for 25(1)(a). Now that the invention for which the patent is going to be granted or has been applied is actually published in a previous patent application filed in India, okay, or it has actually been published in any other document which is published in India or anywhere else, which is prior claiming or prior publication. So it is anticipated under Section 13 in any document which is already published before the priority date or date of filing. Now under this prior claiming or prior publication, there is one exemption that comes under Section 29, wherein if you fall under the exemption category of publication, you have 1 year exemption. If you have displayed it in any government authorized, you have 6 months. So if it is not under those exemption, then those becomes a prior ground for you to oppose a grant of patent. Point number 3 is, if the invention for which a patent is about to be granted or for which a patent is applied and there is a similar patent, however that patent is published on or after the priority date, but its priority date is earlier than the priority of the patent application that is being examined, then that can also be a ground for opposition. Similarly, if there is publicly used or publicly known in India in a particular traditional knowledge, or it has been a practice in India, then that can also be a point of opposition. It is also important to note where there is prior use or publicly used, that also does not include the importation into India, except where such importation has been for the purpose of reasonable trial. Again, these are certain exemptions that is coming under section 29. If the invention is very obvious, that is, it lacks inventive step, that is again an important ground for opposition. If the invention is not as defined within the meaning of the act, so it's not new, it is not what a patent can be within the meaning of the act, then that can also be definitely a ground for specific filing for an opposition. If the invention or the complete specification does not clearly and does not efficiently convey the best method known at the time of the applicant, so he is hidden certain facts, he is not disclosing everything. As we know, patent is granted for the disclosure to public. So if you can prove that he has not given the best known method or he has not provided sufficient data, then that can also be a ground for opposition. If the inventor has failed to disclose to the controller any information under section 8, so under section 8 we have to keep updating the controller every once in 6 months until the grant of patent of all the relevant happenings of the patent outside of India. Whether an application has been filed in the US, there is a PCT application, so we keep updating every 6 months once. So if that has not been complied with, then again that is a ground, or if the person has given any falsified data. Few other grounds of opposition under section 25(1) would also include that within 12 months timeline for a convention application. So the applicant did not or failed to file for a convention application within the prescribed timeline. That any information, especially the geographical origin, was not correctly mentioned in the patent application, or that the invention with which the patent application is related to is something that is known in the traditional knowledge, it is with regard to orally, or it is documented, followed in certain tribal communities, or as a traditional practice. So apart from all of these, there are no other grounds on which an opposition can be made. So an opposition can be made by what all grounds that have now been disclosed under section 25(1), which is basically a pre-grant opposition. Now section 25(2), which talks about the post-grant opposition, again like I said before, this has to be filed within 1 year from the date of grant of the patent, and it has to be filed by any person interested. So at any time after the grant of patent but before the expiry of a period of 1 year, any person interested may give notice of opposition to the controller in the prescribed manner on any of the following grounds. The grounds are almost very similar, like the patentee has wrongfully obtained the invention that has been published before the priority date in any of the patent or in any document in India or elsewhere, provided there is an exemption which you can claim under section 29. Similar to this patent that has been published on or after the priority date of the present application that is being examined, and hence it should not be granted, or it is publicly known or practically used in India, except including importation, except that it should not be for research purposes and it should clearly be only for experimental purposes, or it does not have an inventive step, or that it does not fulfill the definition of an invention within the meaning of this act, it does not sufficiently and clearly describing the best method of performing the invention, the patentee failed to disclose all the information relating to section 8, or he has falsified to the best of his knowledge, patent granted or filed in the convention application did not follow the prescribed 12-month time limit, so he is not eligible to file for a patent application in India, or that the complete information does not disclose or wrongfully mentions the source of geographical origin, and or that the invention claimed has been anticipated by public or traditional knowledge within the indigenous community. Now, these are all almost the same grounds for both pre-grant and post-grant opposition, except that the time at which point you can apply and who can apply varies. Now, when any such notice of opposition is duly given, on receipt of notice of opposition, it's the duty of the controller to notify the applicant that so and so person has filed for a statement of opposition, and he has to send those points of opposition or the grounds of opposition to the applicant, and a board which is called as the opposition board shall be constituted, and the application has to be examined, or if it is a patent grant, the patent grant has to be re-evaluated. Further, section 25 also details about the controller that he has to give an opportunity to the patentee to reply to the grounds for which his patent has been opposed. He has to give an opportunity for both the opponent as well as for the patentee before he takes any decisions which is contravening. And further, it is very important to note that controller cannot take his decision based on any personal documents that is being given to him or involved in any kind of a secret trial. Since there are two parties involved, any document relating to the facts of the ground has to be given to the applicant also. And further, in case if there is any amendment that is required by the controller in order to grant for the patent, the controller has to look at that method instead of directly cancelling or opposing or rejecting the grant of patent. If there is an amendment to overcome the objection, the controller shall also recommend the same. Now, since the opposition cases come to the controller, there are certain guidelines in which a controller can act based on the grounds of opposition being filed. Now, the first important ground which we looked at is wrongful obtaining, which means if an opponent files a case against the applicant saying that the applicant is wrongfully obtained and I am the actual true and first inventor of the particular patent and it is proved to the best knowledge with all the facts, then the controller can actually declare that the application has to proceed in the name of the opponent. So the inventor will now be removed and the opponent who has proved that it is his invention, the application can proceed in his name. Or if it is only a part of an invention that the opponent claims and a part of an invention is actually the applicant, then that part of the invention can be separated and amended and a separate application can also be filed. Now, in case before the controller passes this order, there is the applicant or the opponent has filed another application, then the controller can also amend that other application and change the date of priority, which will be the date of priority of the present application which is being opposed, because he has proved that it is his application. So, if he has already filed an application in his name, then that priority date can be changed to effect the actual priority date in which this application was filed. The previous section talked about wrongful obtaining in terms of a patent application wherein it can be proceeded in the name of the opponent, or it can be amended such that two separate applications can proceed, or the date of priority can change. Now, in case if it is in the name, if it is a granted patent, so what happens? Mention of inventor as such in patent. Now, if the controller is satisfied that the claim of the person that he is a true and first inventor is right according to the controller and the patent is granted, then what the controller can do basically is he can amend the patent and he can substantially make change in all of the corresponding registers and publication that this new person is now the inventor. So it is basically mention of inventor as such in the patent. It is important to be noted that mention of inventor also includes that present applicant or the inventor is also an inventor of the application, that he has forgotten or he has not included the other person who claims to be an equal contributor, then in that case as well, this new person can also be recommended by the controller to be mentioned as an inventor. And for this, the new person or the claimant who is claiming his rights to be a co-inventor or an inventor has to prescribe or subscribe to all the relevant forms to the controller, based upon which the controller can take his decision. It is to be noted that this new person that is added does not confer any special rights over the other inventor, or it does not reduce any of the existing rights of the other inventor. It is also to be noted a request or claim under these foregoing provisions of this section shall be made before the grant of patent. Now, where a claim is made and a notice of claim for every patent is given, then the controller has to pass on this notice of the claim to every other applicant and the inventors of the patent application, and the other person was also given an opportunity to be heard before the controller takes the decision of including or not including the new claimant. Now further, if the controller may, after hearing, if required, any person whom he consider to be interested can also issue such a certificate saying that so and so person is not an inventor and that this person is the inventor of the application. With this, we come to the end of session of opposition proceedings before the grant of patent or after the grant of patent within 1 year, which is a pre-grant opposition and the post-grant opposition. Thank you for listening. Please post in any of your comments or queries. We will feel free to answer it, and please subscribe to be a part of our upcoming series.